Hello, everyone. So, we are in chapter 15 and we are addressing the issue of the individual and international law, which is primarily focused on human rights or the so called international human rights law. If you take a panoramic view of the evolution of international law, one thing that you could recognize is that the individual becoming more visible as a subject of international law. Now, on the question of international human rights law, obviously you have this friction or sometimes this unease between law versus morality, and some people have argued that international human rights law belongs to the so-called aspirational law in contrast to substantive law. So if you look at the Universal Declaration of Human Rights, you could argue that this is more of a soft law than treaty law, and it's more a manifestation of the ideals of modern international law, and it is a work in progress. So, for example, Article 25 of the Universal Declaration of Human Rights reads, "Everyone has a right to standard of living adequate for the health and well-being of himself and of his family, including food, clothing, uh, housing, medical care, necessary social services, right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his or her control." As you can see, this is quite a tall order, and that's why it is sometimes referred to as aspirational law in contrast to substantive or treaty law. Now, there is also friction because of the aspirational components of international human rights law between its theory, the way it's conceptualized, versus its actual practice. And this is a friction between the notions of Westphalianism that give this complete freedom from interference and complete sovereignty to the state versus human rights principles that could potentially encroach on the sovereignty of the state. But in this chapter, we're going to be focusing on the instruments and a bunch of treaties and other documents that collectively comprise modern international human rights law. So you have the Atlantic Charter. These are the instruments before the end of World War II. So you have the Atlantic Charter in 1941, the Tehran Declaration in 1943, and eventually the United Nations Charter, which recognizes universal fundamental freedoms. But the problem with the United Nations Charter is that it doesn't contain any sanctions or enforcement mechanisms specifically dealing with human rights. So it pays more of a lip service to human rights than figuring out a concrete mechanism to operationalize those aspirations. But the watershed document and the evolution of international human rights is the Universal Declaration of Human Rights in 1948, which is generally agreed to be the foundation of international human rights law. This instrument has inspired a quite diverse and rich body of legally binding international human rights treaties that we will cover in this chapter. But the Universal Declaration of Human Rights, along with two other documents, comprise the so-called International Bill of Human Rights. Those two additional documents are, number one, the International Covenant on Civil and Political Rights, which has two optional protocols. This is normally referred to as ICCPR in international law. And the second document is the International Covenant on Economic, Social, and Cultural Rights. So these three documents collectively are referred to as International Bill of Human Rights. Then you have a bunch of other mechanisms that reinforce or complement the International Bill of Human Rights. They include the Genocide Convention of 1948, the Refugee Convention of 1951, and probably most importantly, in terms of presenting a paradigm shift in the evolution of international human rights law, the European Convention on Human Rights in 1950, which establishes the European Court of Human Rights in 1959. So the ICCPR of 1966, like I said, this is one of the instruments of the International Bill of Human Rights. This document commits its parties to respect the civil and political rights of individuals, including the right to life, freedom of religion, freedom of speech, freedom of assembly, electoral rights, and rights to due process and a fair trial. And it has two optional protocols. The first protocol commits the parties to recognize the competence of the United Nations Human Rights Committee to consider complaints from individuals who claim their rights under the covenant have been violated. So essentially, the individual could file a complaint, which is a revolutionary concept if you think about it, because ordinarily that right in international law is reserved for state actors. The second optional protocol abolishes the death penalty. Again, another potentially revolutionary achievement, or aspiration at least. Apart from the previously mentioned documents, you have the so-called 7 core treaties of international human rights law, which are mentioned on this slide. And these include the ICCPR, which we've covered before, also the Convention on the Elimination of All Forms of Racial Discrimination. This was adopted in 1966 and entered into force in 1969. Then you have the Convention on the Elimination of All Forms of Discrimination against Women, adopted 1979, entered into force 1981. You have the United Nations Convention Against Torture, adopted 1984, entering into force in the same year. Convention on the Rights of the Child, CRC, adopted in 1989, enters into force in 1989. Also, the Convention on the Rights of Persons with Disabilities, again, adopted 2006, enters into force in 2008. And finally, the International Convention on the Protection of the Human Rights of All Migrant Workers and Members of Their Families, that was adopted in 1990 and entered into force in 2003. In terms of the bodies affiliated with the United Nations that deal specifically with human rights, you have most importantly the United Nations Human Rights Council, which is a subsidiary of the United Nations General Assembly and works in tandem with the Office of the High Commissioner for Human Rights. And its primary function is the promotion and protection of human rights stipulated in the United Nations, in the Universal Declaration of Human Rights. One of the mechanisms for promotion and protection of human rights is the appointment of special rapporteurs, which deal with specific themes or specific countries that are more prone or are perceived to be more prone to violate international human rights norms. So we have, currently I think you have special rapporteur for countries like Burma, North Korea, Cote d'Ivoire, or Ivory Coast, Kyrgyzstan, Syria, Libya, Iran, and Sri Lanka. And some of the themes that the special rapporteurs deal with are contemporary forms of slavery, extrajudicial summary or arbitrary executions, protecting human rights while countering terrorism, racism, racial discrimination, xenophobia, and related intolerance. So these are some of the issue areas that the Special Rapporteur deals with. So apart from the United Nations mechanisms, you also have regional mechanisms to promote and protect human rights. Europe is arguably at the forefront of that regional effort to promote human rights, primarily through the European Convention on Human Rights and the European Court of Human Rights, whose Protocol 11 allows individuals to apply directly to the court. And like I mentioned, this is a revolution in and of itself because it allows individuals, regardless of their nationality, to go to the court and file a complaint against a violator of human rights. And Protocol 13 of the European Court of Human Rights provides for the total abolition of the death penalty. And as we've talked about this before, the death penalty is one of the sticking points in, for example, extradition treaties between the United States and the European Union. Apart from Europe, you also have regional human rights mechanisms in the Americas through the Organization of American States, which has these two mechanisms to deal with human rights, the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. Obviously, these two mechanisms are far from the development and the maturity of the European mechanisms. So next slide is on the U.S. attitude towards human rights conventions. And I've just here essentially just summarized the broad contours of how the United States views these human rights instruments and conventions. Number one, the United States believes in the sufficiency of U.S. Constitution and Bill of Rights and its supremacy over international human rights mechanisms. In other words, according to the United States, the Bill of Rights cannot be abrogated by agreements with foreign powers. The United States has also been traditionally reluctant towards international arrangements and intrusions, partly because of the fear of their impact in diluting Americanism. Sometimes it's referred to as human rights interventionism. The United States has also been historically skeptical towards the International Court of Justice and compulsory jurisdiction because in the United States you have this firm belief in the supremacy of sovereign prerogatives, the so-called sovereign prerogatives doctrine that I think we've covered before. The United States has also been wary of the impact of these human rights conventions on the balance of rights between states and the federal government, especially when it comes to self-executing treaties. Obviously, U.S. has been, concerned on the impact of these human rights conventions on eroding sovereignty and their impact in creating opportunists with justification to criticize U.S. practice, which has happened historically in those human rights conventions. And part of this skeptical attitude towards human rights conventions in the United States is this belief that these conventions have this potential or this inherent anti-capitalist, leftist, communist, socialist bias. And because of all those concerns, the United States has adopted this policy of slapping various reservations, understandings, and declarations, the so-called RUDs, on Human Rights Conventions. And this really starts with the ratification of the Genocide Convention, which was a very laborious and a lengthy process, as a result of which the US Senate decided that as a condition of its consent to the Genocide Convention, it would systematically append a number of these reservations, understandings, and declarations to each human rights treaty in order to limit the impact of these treaties on domestic U.S. law. So, so the U.S. attitude towards human rights conventions could be summarized through the so-called Bricker Legacy, which, essentially gives priority and supremacy to the United States Constitution. It also believes in the non-jurisdiction of International Court of Justice on human rights issues, and it also establishes the enabling legislation requirement of human rights treaties. It also does not believe in litigation by individuals, and it enshrines the sanctity of federal state balance of rights, which is, part of U.S. tradition. So as a result of those reservations that the United States has towards the international human rights law regime, the United States has not ratified a bunch of signature human rights instruments, and these include the Convention on the Elimination of All Forms of Discrimination Against Women, Convention on the Rights of the Child, Convention for the Protection of All Persons from Enforced Disappearance, Mine Ban Treaty, Convention on Cluster Munitions, Convention on the Rights of Persons with Disabilities, and Optional Protocol to the Convention Against Torture.